Your intellectual property, your IP, your code, your trade secrets, your content, it is the single most valuable asset your startup owns. But here's the cold reality. Just because you build it doesn't mean your company or nonprofit legally owns it. This is a critical legal formality that is often overlooked in the excitement of formation. My name is Maritza Shea Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that legal stuff might come back to bite them. For any new startup, especially those founded on novel technology or some sort of creative works, whether that's content or music or art, whatever that might be, the single most critical legal step is securing ownership of that core intellectual property. Failure to do so creates what you can call an IP gap, a foundational flaw that can sabotage future investment in the company, potential acquisitions of the company, or even just the company's very existence. This IP gap typically manifests in one of two common yet legally precarious scenarios. The first is the pre-formation IP problem, or what you might call the hobby trap. This occurs when the initial valuable IP assets, whether that's conceptual design, a functional product, a prototype, the first iteration of source code, proprietary algorithms, that first core key piece of content that you're planning to sell, that was all created by you as the founder before the company was officially incorporated or legally organized. And it's common for the founder like you to spend months or maybe even years brainstorming and putting it together, whether it's a minimum viable product or that content that you're ultimately planning to use to launch the business. And a lot of times you've done this as a side project. And then you need to make that leap to official, formal incorporation or organization of a business. Well, when a person creates an invention or a work of authorship, they legally own it personally. If the IP was created before the company existed, then the company doesn't automatically get to claim ownership. There has to be some type of deliberate formal transfer. The second type of IP gap is a lack of a formal agreement. So this is the trust trap. This scenario arises oftentimes after the company has been formed, when key individuals, so whether that's the founders, early employees, sometimes even independent contractors, haven't signed a formal, legally binding document transferring their creative, intellectual property, or even inventive rights to the company or nonprofit. The absence of a signed legal contract explicitly assigning these IP rights means that the individual creator, not the company, is still deemed the owner of the asset that was created. Personal trust and a shared vision is absolutely invaluable, especially in those early days, but they are not legal substitutes for a contract. The IP gap is not some minor legal wrinkle. I'm not here trying to bother you about legal nuance and the nerdy details that we attorneys like to geek out on. This is a basic pass-fail test for any serious investor when they're doing their due diligence and thinking about investing in your organization, or later on down the road when you say, hey, this has been awesome, I'm ready to sell it to perhaps a bigger company, and now they're coming in and taking a look at things and going, it's not much here of value. From an investor and buyer perspective, their primary goal is to buy equity in a company that legally owns the assets that generate the value. If the company can't prove with clear signed documentation that it actually owns its core technology or its core content or whatever those assets might be, then it really doesn't have anything of value to sell or even secure when we talk about copyright or trademark registrations. A company that can't demonstrate clear chain of title for its intellectual property will be viewed as fundamentally uninvestable or unacquirable. Maybe if you get lucky, they agree to do a side deal with you personally, but that's a big maybe for what a lot of people are planning as their long-term exit strategy or retirement plan out of their business. This single issue is often cited as one of the top reasons for severely impeded valuations, i.e., this company isn't worth what you think it's worth, delayed deals, or just the deal collapsing altogether. The good news is that this critical risk is easily mitigated with a standardized and essential legal document, what we often call a Proprietary Information and Inventions Assignment Agreement, no, mouthful, or a PIIA. Sometimes you might also see this referred to as a technology assignment agreement, especially if you're doing more of a tech startup. Every single founder, yes, you, even the founder, and ideally every person who contributes to the company IP, including employees and consultants, must sign an agreement like this. I always tell people I'm not so much concerned about what we call the agreement as the actual substance of it. But for simplicity's sake, we'll talk about it as this proprietary information agreement. So what does this achieve? First thing is a comprehensive transfer. It ensures a complete legal and formal transfer of all of the IP rights, whether that's patents, copyrights, trade secrets, trademarks, from the individual creator to the company or nonprofit organization. 2, retroactive coverage. Crucially, these types of agreements will contain specific language to address any pre-formation IP problems, so legally assigning the rights to any relevant IP, even if it was created before the organization was actually formed. And 3rd, future-proofing. These agreements cover the IP that was created after the company is formed and while the individual is associated with the company, whether as an employee or a contractor, preventing that whole lack of an agreement problem from occurring as we move forward. By executing a PIIA, or Proprietary Information and Inventions Assignment type of agreement early and comprehensively, the founders aren't just checking a box, right? We're not just running up billable hours. You're actually taking time to secure your innovation and transferring a mere idea into a legally protected, owned, and auditable asset, the true foundation of a scalable and valuable business or even nonprofit. Making these critical transfers simple and seamless is the first and most important step to getting back to the business of building. Proactive legal work is about making sure your paper trail protects your brilliant idea. Don't build a treasure chest with a hole in the bottom. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you love what you do and want to build something amazing, or better yet, take amazing to the next level, then let's talk. Check out the link in the description to schedule a consultation. Don't forget to like, subscribe, and leave a comment.